Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Hi there, and welcome to Ask a Lawyer. If you're not sure what your workplace rights are, this is the show for you. Welcome to the show. I'm your host, John Scholes. Every week we shatter myths and clear out the confusion about your employment rights in Canada and how to get the advice and compensation you need. Joining us is employment lawyer Lior Samfiru, partner at EmploymentLawyer.ca. Now, before we get into today's questions and phone calls, Lior, tell us why it's so important that everyone knows about their employment rights and maybe a case from the past week that we can all learn from. How about that?
Well, John, employment law, unlike other types of law, is a law that you can use. It's relevant. It's something that affects you every single day. Hopefully criminal law is something you don't have to access too many times. Real estate law, maybe you buy one or two properties in your lifetime, but employment law is something that impacts you every day. We all have jobs. We all spend a lot of time working. So employment law is what tells us what we need to know when you're dealing with a workplace issue, a workplace dilemma, a problem. We have rights, we have laws, we have things that we can do. Unfortunately, too many people don't understand what those rights are. And on the show, we educate and inform you about those rights. We tell you what you need to know, and we help you navigate the maze of employment law. So if, in fact, you're dealing with a workplace problem, or maybe you're just being curious about your rights, you want to understand what to do if you're ever in a bad situation, this is the show, this is the time, this is the place. We're going to educate you on that, and we're going to make sure that the rights that you may not know you have, now you're going to know, now you're going to be informed. So with that said, John, let me tell you about a situation that came across my desk over the past few days. One of the most common myths, one of the most common misconceptions about employment law has to do with severance that's owed for short service employees. I have spoken with hundreds of people over the years that lost their jobs after a few months only of working. And they always say, well, I'm probably owed a week's pay. Maybe if I'm really lucky, I'll get 2 weeks' pay. And is that true? Well, let me tell you about a situation that came across my desk. I spoke with a lady earlier this week. She had worked for an employer for 2.5 months. She was let go, not because of anything she did. They just decided it wasn't the right fit. It happens, not the end of the world. She contacted me, actually, because she wanted to know how can she get back the company or her property that's at the company. She had some personal items in the office, and she wanted to get that back. So I talked to her about how to get that. But then I asked her some more questions, and I found out that after 2.5 months, she did not get any severance. She'd assumed she was not owed anything because she had only been there for 2.5 months. Not true at all. In fact, she was owed as much as 3 months severance. John, she's worked there for less than 3 months, and she was owed about 3 months of severance. That is very common with short service employees. Short service employees get more or disproportionately more severance than longer service employees. And the other thing I want you to remember is that there's no such thing as automatic probation. You're not on probation unless you sign an employment agreement that says so. Probation is not automatic, okay? You're not necessarily on probation just because you started another job or a new job. So many times you do get severance even as a short service employee. And of course, longer service, that means even more severance. But I don't want anyone to think that their severance is going to be a week's pay, maybe 2 weeks, just because they're short service. You're not sure what it is. You're not sure how much you're owed. Or if you've been offered the right amount, just give me a call.
Reach out, contact employment lawyer Lior Samfiru and his team directly by going to EmploymentLawyer.ca or calling 1-888-861-4555. All right, time for the first call of the show. Lior gets these calls from our radio show, which we've been doing a long time across Ontario. The Employment Law Show heard Sundays at 1 o'clock right here. News Talk 1010. Now, before we take live questions from listeners about their employment law concerns. So let's listen to our first one. What do you say?
My wife was working for a company for just over 8 years. She was an administrative assistant. Big company, giant payroll. Originally, she was laid off a year ago, but she was pregnant and going on maternity leave. So they said, okay, we're not going to lay you off. Kept her on as an employee, so in order she had benefits for that year, and told her that they would review her and try and get her a position back when she came back the year later. That didn't pan out, and they gave her a total of 9 weeks of severance.
Yeah, you can't see maybe, but John here is shaking his head.
Yeah.
And John knows what I'm about to say, that this, I'm going to quote you, this is a whole bowl of wrong.
That's
Okay,
right.
it is.
Yeah.
Well, let's start with the maternity leave aspect of it. First of all, an employer cannot decide before the maternity leave ends that they're not going to bring the person back. That assessment has to be done at the end of the leave. And if there's any possibility, the employer has to bring the person back, whether it's a father or a mother that takes the parental leave, they have to be brought back. Now, if it's impossible, the job doesn't exist anymore, something's happened, maybe the department shut down and there's no job, then and only then can a company terminate employment. And too often, companies don't do that. They don't bring the person back from parental leave. That is illegal. Now, assuming there's a legitimate reason that the person was not brought back from maternity leave, the question becomes severance. Is that appropriate? We know that this person got 9 weeks of severance after 8 years. My gosh, is that enough? Well, before I even tell you, let me show you if it's enough, and let me show you how you can find out as well. We're going to use our severance calculator tool, which you can find at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Let's plug the information into that severance calculator, and let's see if 9 weeks is enough. We know that this person has been there for 8 years. She's 58 years of age, was offered 9 weeks. Well, 9 weeks is not enough, and you see on the screen that this person is actually owed 10 months of severance. 10 months. That's a massive difference between 9 weeks and 10 months, and that is a very common situation. Chances are, if you've been let go, even if the reason for the termination is otherwise legal, chances are that whatever you've been offered, whatever you've been paid, is pennies on the dollar. It's a fraction of what you're actually owed. That's why it's important you use the severance calculator or you give me a call so that you can get what you're owed.
All right, good stuff. Let's take a quick break, and when we come back, employment lawyer Lior Samfiru from EmploymentLawyer.ca will outline how you can best preserve your workplace rights. That's coming right up.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is here tackling questions about your workplace rights. Get in touch with Lior and his team anytime. Email ask@employmentlawyer.ca, or you can call 1-888-861-4555 or go to employmentlawyer.ca. We'll get to more phone calls and questions in a moment, but first, today's main topic, how to preserve your workplace rights. First one, Lior, don't quit unless it's completely voluntary.
So we're going to talk about a few situations where you have to keep in mind, you have to do things or avoid doing certain things in order to preserve your rights. And the big one, it's the good place to start is quitting. Never quit unless it's voluntary. So let's start with the idea that a quitting or a resignation is only a resignation if you do it voluntarily. By definition, it's something that an employee does voluntarily, not because they're told or threatened, okay? So if you're told to resign, if you're told you have to give me my letter of resignation by tomorrow, that becomes a termination. So don't do that. Oftentimes your employer is going to demand your resignation because they want to try to avoid paying you your severance. They know that if they let you go, they have to pay you severance. So, hey, I know. Why don't you just resign and then I can save a bunch of money and now you don't have to get your severance. Don't do that. Don't gift your employer your severance money. So if your employer says to you, I want you to resign, the answer should be, no thanks. I'm not going to resign. If you want to let me go, I can't stop you, but that's on you. I am not going to resign. And you can't be told, you can't be made to resign. And if you're ever in that situation, you have to get on the phone and give me a call.
Okay, Lior, next one is Lior explains how to preserve your workplace rights. Don't take one for the team at your own expense, right?
And here's what I mean by that. Take one for the team is maybe your employer wants to do something, maybe give a pay cut, relocate you, change your hours, and you say, I want to be a team player, so I'm going to take one for the team. I'll accept this change. The problem with that is that once you accept this change, you may be stuck in that change forever. So you think, well, I'll do this, but now you're stuck in that change. But it gets worse than that. You took one for the team. The one can be many. And the reason for that is you took that pay cut, you took it for the team, but because you took it for the team, you accepted that pay cut, now the company has the right to do it again and again. You thought you're taking one. You thought it's going to be an isolated incident. But because you did that, you're now in a situation when it can happen multiple times, and then you won't be able to do anything about it. When it comes to these changes to the terms of employment, the concept of constructive dismissal should come to mind. Your employer does not have the right to make significant changes, and you can treat that as a termination and get severance. And in many cases, you would rather do that than accept one, take one for the team, accept the change, because then you may find yourself in a very difficult situation.
We are talking about ways to preserve and protect your workplace rights here on Ask a Lawyer with Lior Sanfiru. Number 3, don't forget about your employer when you're on a medical leave.
Very important. Yeah. Good advice is this. If you're going to be off work for a while, if you're not going to be just a few days or a few weeks, you're going to be off for a few months or maybe longer, don't forget about your employer. What I mean by that is you want to be in touch with your employer. You want to send them a note every once in a while, reminding them that you're there, reminding them that you're working on getting better. What you're trying to avoid here is a situation where your employer says, hey, I hadn't heard from you in all these many months. I thought you resigned. Now I don't have a job for you. And that could almost be a reasonable thing for the employer to say. So instead of that, maybe once a month, I think a good rule is once a month, send a brief email. It could be 1 or 2 lines. Hey, employer, just so you know, I'm still working on getting better. I'll be in touch when I have more to say. That's it. That's all you need. By doing that, you're preserving your rights. You're preserving your job. You're going to make it impossible for your employer to say, I assumed you quit. I don't have a job for you. So preserve your rights by staying in touch with your employer when you're on the leave.
That's what we're talking about, preserving your rights, workplace rights. Number 4, file a complaint with the Ministry of Labor if you lose your job. Always an awesome thing to do.
Always the worst thing to do.
That's right.
The easiest, most extreme way to lose your rights is to go to the Ministry of Labor if you lost your job. Let's be very clear what I'm talking about. When it comes to your entitlements on termination, your severance, your employer, or the Ministry of Labor, I should say, can only help you enforce your minimum entitlements. That's a small fraction of what you're actually owed. But it gets worse than that. Once you file that claim with the Ministry of Labor for your severance, you're then prevented from pursuing your full entitlements. You can't do it. You essentially gave up your rights, and that could be tens of thousands of dollars. You may file a complaint with the Ministry of Labor, and they may be able to get you 3-week severance, where in fact you could be owed 12 months of severance. And then by filing that complaint, you gave up your rights. So never, ever go to the Ministry of Labor if you lost your job. You can go there for overtime pay, for vacation pay. You can go there for holiday pay. When it comes to losing your job, losing your severance, you have to speak to me. If you don't like me, speak to another employment lawyer. But there's no exceptions to that.
Okay, last point about preserving your workplace rights. Have an employment contract reviewed before you accept it, before. Right?
One of the most common things that an employment agreement does is it takes away rights that you would otherwise have. So you have all these rights. We all have all these rights that are there. They're automatically there. But we also have the right to give them up. And an employment agreement often takes away the rights that we would otherwise have, eliminates them, because an employer may say, hey, I'd rather my employee not have those rights. And oftentimes, that's what an employment agreement does. For example, it could limit your future severance. It could cost you tens of thousands of dollars just that way. It could give the company the right to change your job, your pay, to put you on a temporary layoff, you name it, and many other things as well. So when it comes to an employment agreement, don't just look at how much the salary is or how many weeks vacation. There are other terms that are at least as important, if not more important. And if you're not sure if you should accept it or sign it, send me a copy. Let me review it and let me tell you whether you should be concerned about it. You don't want to give up your rights without even realizing it.
Okay, Lior, let's switch gears here a bit. Let's listen to another phone call from one of our long-running live radio shows right now.
I worked for a company for 4 years, technical position, 42. I went on short-term disability. At the end of the short-term disability, they denied long-term disability, even though I'm still in a lot of pain and unable to work regularly. Now I've got a severance letter.
Gosh. So
Yeah.
I've seen this so many times, and it breaks my heart every time I see this. You can't work. Your doctor says you can't work. You know you can't because you're sick or you have an injury. Your insurance company cuts you off. Now you don't get paid. And then your employer says, well, because you're not working, we're going to let you go. Wrong, illegal, and it's taking a bad situation and making it worse. So let's first deal with the insurance company issue. And this I see happen often. An insurance company says, well, we don't think you're disabled enough. We don't think you should be off work. And so we're going to cut you off or deny your disability benefits. Wrong. If your doctor says you can't work, that should be enough. And we have a whole team at the office just dealing with that. So if you find yourself cut off your disability coverage, let's talk. I'll connect you with one of my colleagues that deals with this exclusively. They can either get you back on those benefits or get you compensation. Now, with respect to your employer, it's actually very similar. If your doctor says you can't work, you can't be let go. They can't demand that you come back to work contrary to what your doctor says. And again, an employee should never be let go because they're on disability or while they're on a disability. So in this particular situation, this person certainly got the raw end of the deal. I can certainly help with that, and same with you at home. If you're sick and your employer does anything to you or your insurance company cuts you off disability coverage, we need to talk, and we need to talk right away.
You can connect with Lior and his team, emailing ask@EmploymentLawyer.ca or going to EmploymentLawyer.ca. And after the break, we'll talk about probation following a request for a raise and what happens when promised promotion falls through on Ask a Lawyer. That's on the way.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask an Employment Lawyer. Lior Sanfiru here from EmploymentLawyer.ca, taking questions about your workplace rights, don't you know? To get in touch with Lior and his team anytime, email ask@EmploymentLawyer.ca, call 1-888-861-4555, or visit simply EmploymentLawyer.ca. Still got lots more to get through, including this call that came into one of our long-running radio shows, which airs Sundays, 1 p.m., News Talk 1010. Let's listen to that.
I've worked for a company for 8 years. I was security supervisor at a hotel. I hadn't had a raise in 6 years. When I approached them about a raise, they put me on 6-month probation and terminated me before the 6 months was actually up. They claimed that it was misconduct. I had no issues before that. I got no severance. They owed me 2 weeks of vacation, so I got absolutely nothing from them.
It's a good deal.
Oh my God. Well, what is this employer thinking? I mean, unbelievable. Well, let's start with the probation, actually. You really can't be put on probation once you've already worked for 8 years. It becomes meaningless. Probation is something that happens at the beginning of the employment relationship, if at all. So right off the bat, that's nonsense. And for him to be let go without severance for misconduct, he would have had to do something pretty awful, pretty bad. And asking for a raise is not that at all. So unless he hit someone or stole or was abusive, it's not going to be a for-cause termination. He's going to be owed severance. So the question now becomes how much severance he's owed. Easy to do. We're going to go back to pocketemploymentlawyer.ca. We're going to use our severance calculator tool, and we're going to see exactly how much severance he's owed. And by the way, you can do the same thing at home. So that we know that this guy is a supervisor, been there for 8 years, 48 years old, didn't get any severance for some silly and illegal reason. But we see on the screen that he's owed as much as 14 months of severance, somewhere between a year, 12 months, and 14 months. That's what he's owed. That's a wrongful dismissal. And by the way, you can do the same thing at home. You can go to pocketemploymentlawyer.ca. You can find out how much severance you're owed. It's free. It's anonymous. The first place you go to if you want to find out what severance is like for you.
And to get in touch with Lior and his team, email ask@employmentlawyer.ca, call 1-888-861-4555, or visit employmentlawyer.ca. It's time for another question, Lior. This one from our one of our live streams on Facebook and YouTube, which can be found, by the way, at stlawyers.ca, at stlawyers.ca. I was promised a new promotion, a key promotion actually last year, throughout the office, and that was all set in stone. This year, didn't happen. It was given to a coworker instead. Can my employer do that?
Well, they can't if you can show that there was a promise for a promotion. So the problem with something like that is unless there's something in writing, it may be difficult to enforce. Now, if it was in writing, you're getting a promotion and you didn't get it, that could absolutely be a constructive dismissal. You were promised something, you proceeded on that basis, and you didn't get it. So a good piece of advice is this. If your employer promises you a promotion, promises you a pay raise, promises you a change in shift, get it in writing, or at least send them an email yourself telling them, confirming what happened. By doing that, you're going to make it enforceable. You don't want to be in a situation where the company says, I never told you that, I never promised you that. But yes, you can enforce on a promise for a promotion as long as you can prove it.
We'll take a break and return with Lior Samfiru, partner at EmploymentLawyer.ca. Fired for cause over a small incident at work. Lior will address your rights next on Ask a Lawyer.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, welcome back to Ask a Lawyer. Let's take a look at another situation that your firm has come across recently. After working many years as an electrician for a mining company, I was fired for cause after getting into a heated exchange with a new supervisor. This was my first and only incident on file. Can they just fire me like that, Lior?
Well, the thing is this, John. One incident of misconduct is almost never enough to be cause. Almost never. Unless you stole or you hit somebody, it's just not going to be enough. No, I want to say this. He may not have done the right thing here, but that's still not cause. Unless you did something awful, you are still owed severance, and I want to hear from you in that situation, John.
Another great show, Lior. Thank you so much for your time. You want to reach out anytime you can. Radio show live on News Talk 1010 every Sunday at 1 o'clock. The Employment Law Show, where he takes calls from our radio listeners across the GTA. Catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show and EmploymentLawyer.ca is where you go. Visit cp24.com/askalawyer. Join us next week as we look at some of the most ridiculous allegations of termination for cause. Thanks for watching.